So glad to see everybody here today for such an important topic. I'm really glad that we get a chance to learn about this legislation that really impacts all of us in serious illness care. I can report that it was introduced yesterday, the legislation was, so it will be something where there will be hearings coming up. So hopefully people will learn today and be thinking about what kind of testimony they would want to introduce. Fortunately, we have imported an expert from the continent, Jennifer Moore Ballentine, to talk about this legislation. I just wanted to say a couple things. If this sounds familiar, that's because it is. This legislation last year was something that we all missed until it had gone through all of the hearings. So thank goodness it was recommitted, which means killed in legislative parlance. But it's back now. And as I said, it is being reintroduced. So it's something that I hope we all can learn about. Jennifer is going to talk about the bill as an overview, and then also we'll talk about some specifics or some concerns that she has. And then we certainly have the chance to ask questions. So again, please be thinking about inputting about testimony if that's something you're going to want to do, especially telling stories of how this legislation could impact you. I also do feel that it's important to say that Kokua Mau, we are one of the places that people go to in the state for information on advanced care planning and advanced directives. I love it that people all across the state thank us for translations in 13 languages, easy to download forms. Hope and I do trainings around the community. We did not hear about this bill. We were not approached for input. So it is a little bit disappointing that that didn't happen. But now we do know that it's out there, and so now we have a chance to respond. First, we're going to hear from Jennifer, and then Marilyn Seeley's on the call, who helped put together the Uniform Healthcare Decisions Act first go round back in '98. I also have some links to the public access room to help people who don't know how to write testimony or this is their first time. And of course, you can always ask me about that later. So without further ado, I'm going to introduce my friend and colleague, Jennifer Moore Ballentine. She and I have worked together for many years, and I am so grateful that she stepped up today to help us understand this legislation. I actually know about this legislation because of Jennifer. She did a presentation both at a CTAC meeting and then at the California Coalition's amazing meetings. That was, I guess, 2 years ago. So Jennifer, just a short bio for her. And again, if we were in person, we could give you a lay. And if I was active, I could have pulled up a slide with a lay, but just consider yourself given a lay there. Jennifer is the CEO of the Coalition for Compassionate Care of California, which is actually a sister organization to Kokua Mau. She is an educator, consultant, and advocate with more than 25 years of experience and expertise in palliative care and hospice care, adult education, healthcare ethics, and policy. She's the former executive director of the California State University Shiley Haynes Institute for Palliative Care, and previously has held leadership roles for the Life Quality Institute, the Denver Hospice, and the Colorado Center for Hospice and Palliative Care. And Jennifer and I also serve together on the National POLST Board. So Jennifer, thank you for stepping up and helping us to understand more about this important legislation. So please take it away. So thank you, Jennifer.
Thank you, Jeanette. It's great to be with you. I wish I were there in person. I still have the lay that you gave me back in May. It's draped over my mirror in my room. So anyway, great to be with you all. I seem to be tapped to do this for my sins. Advanced care planning is an area of keen interest, for me. I came into this field 25 years ago because of advanced care planning and because of my passion around it. So I follow these things and was following very closely the the revision of the Uniform Healthcare Decisions Act, and that's kind of what got me into this trouble in the first place. So I am not an expert on your statutes and legislation. I have spent the past 24, 48 hours doing a deep dive into existing law and the proposed legislation. And what I'm going to try to do is kind of bring to you a perspective, sort of an overview, as well as kind of some point out some places where I think there are some problematic provisions that you might want to consider, as well as some devil in the details that you might want to dig into a little bit further. I'm sure if anyone here were to lay the several pieces side by side and do a really close textual analysis, you would turn up more. But this at least will give you a taste of what's in there. So that in mind, the agenda today, I'm going to give you a little bit of background. I'm going to recap what some major provisions in your existing law, that both the Advanced Healthcare Directive, Uniform Healthcare Decisions Act, and the Mental Healthcare Directives Act, because my sense from Jeanette is that particular statute is perhaps not as well known. And, it's interesting to see how the two interplay, and then talk about the proposed legislation and identifying some things that, again, in my opinion, I think are possibly pretty good. I have some good news for you, and a few things that are extremely problematic, I think, again, in my opinion. And then some other things that are kind of, depends on where you land on certain things as to whether they're going to be good or bad, or whether they're just kind of confusing. So that's where we will go. So a little bit of background here, as I think most of you will know, the Patient Self-Determination Act was passed in 1991 that really supercharged a lot of work around advanced care planning and advanced directives. By no means was that the beginning. The living will dates back into the 1940s, and the first really popular living will was circulated in the 1960s. And of course, it was the 1970s and the 80s where the tragic cases of Karen Ann Quinlan and Nancy Cruzan really brought the importance of surrogate healthcare decision making to the fore, and the importance of having end-of-life wishes in particular documented, which led themselves to the Patient Self-Determination Act, which went into effect in 1991. The Uniform Law Commission then, and the Uniform Law Commission does a lot of work across all sectors, across all aspects of law and industry, developing model legislation that can then be adapted by states and passed one at a time in different states. So they started work in the early 90s on a Uniform Healthcare Decisions Act, which was then approved by the Uniform Law Commission in 1993. And then was promoted, to a lot of different states. I can't recall and couldn't find the exact number of states that adopted some version of the Uniform Healthcare Decisions Act. It's fewer than you think, because by the time they got it approved and promulgated, a lot of states had already done something with respect to advanced care planning or advanced directives. But nevertheless, it was influential. And as I understand, the Hawaii passed its version of the Uniform Healthcare Decisions Act in 1998, went into effect in 1999. And then in 2004, passed a separate statute allowing for advanced directives for mental health care, which we'll talk about a little bit more. And this, too, is a trend across the US. A number of laws were kind of getting going. And more about that in just a second. This is a little rough because I kind of threw this together in the last 24 hours, so forgive me if I sort of repeat myself. But in any case, then over the past, I want to say 5 or 6 years, the Uniform Law Commission went back to the Uniform Healthcare Decisions Act and decided, we really need to update this and to, in particular, take into account electronic completion of advanced directives and electronic storage and retrieval of advanced directives, as well as some other revisions that were sort of prompted by the long history now of 30, 40 years of advanced directives being in place, and wanting to sort of modernize the act. So as I mentioned, a little more background. So 1960s forward were the earliest versions of advanced healthcare directives focused on preferences for life-sustaining treatment in the context mainly of terminal illness and or permanent incapacity. Late 1970s really started going with following the Karen Ann Quinlan case and Nancy Cruzan in the 80s, the importance of having a power of attorney for healthcare. And then in many states, those two documents or instruments are still separate. There's a power of attorney for healthcare, and then there's something called the living will or the instructions for healthcare. A number of states have combined them, California being one, and Hawaii ultimately as well. From the 1990s forward, there's been a sort of a further attention to treatment preferences for any serious illness, not just at the end of life, not just life-sustaining treatment. And this would include the push around POLST and medical orders for life-sustaining treatment, but treatment in the context of a serious illness and not necessarily right out to the brink of death. But most of the advanced healthcare directives really have had an emphasis on physical health, on physical illness, terminal illness, chronic illness, progressive illness. But around the 1980s, there started to be sort of a push for having something similar for psychiatric or mental health conditions. And this was, especially stimulated following the deinstitutionalization for mental health in the 1980s. Thank you, President Reagan. When a lot of mental health facilities were closed and people were put back into the community for better or for worse, but they really needed at that point an instrument to allow those patients to retain some control over their treatment, and particularly as they're cycling through different stages of the illness and relapse and recovery and so on. So starting in the late 1990s, we started to see the first state laws that were specific to mental health directives. A lot of them were just folded into the existing advanced healthcare directives, and a few were separate statutes. By 2025, 27 states have a separate psychiatric advanced directive or mental health advanced directive statute. Now, the interesting thing is that there's kind of a difference in the way I see it anyway. There's kind of a difference in philosophy and a difference in implementation of the two advanced directives. Advanced healthcare directives, as we know, really they had their beginnings in very end of life care, terminal illness, permanent incapacity, more broadly serious illness, people who might have a condition that would put them at risk of not being able to speak for themselves. But it's really about serious illness care and illness that you probably either are living with long term or may not recover from or will only get worse. For psychiatric advanced directives, the goal was to put forward awareness of treatment preferences during a psychiatric crisis, a psychotic break, somebody, coming off their meds, somebody having an exacerbation of a mental health condition, but from which the person is likely to recover. So the population and the purpose of psychiatric advanced directives or mental health advanced directives and advanced healthcare directives are somewhat different. And that's part of what makes meshing them into one statute or bringing the two together a little bit challenging because it's kind of a different purpose. And the context in which they might be invoked is somewhat different as well. So for instance, if someone is having a psychiatric crisis, the first responders may well be law enforcement, not necessarily EMS. They might not be presenting to an emergency department. They might be having a crisis in the street. So some of the practical implementation of how do we know there's a psychiatric advanced directive? What does it actually specify? What force does it have? How do we access it? Are all practical considerations for the implementation of a mental health directive that are somewhat different from an advanced healthcare directive. So that's just some background to keep in mind. So existing law in Hawaii, as I mentioned, you have these two statutes. One of them is the Uniform Healthcare Decisions Act modified, meaning that you took the Uniform Healthcare Decisions Act, but you didn't adopt it wholesale. You modified it and made it your own, dating back to 1999. And that's in your revised statutes, Section 327E. And then you have this Advanced Mental Health Care Directives Act, which is 327G. Thank you, Jeanette, for providing me with those statute numbers and the links. So comparing the two, the Uniform Healthcare Decisions Act, provides instructions for healthcare. It also provides for the appointment of a healthcare power of attorney, an agent and alternates. It also has a very detailed default surrogate process, of which I hope you're all familiar. And it's somewhat unusual. Colorado actually has a similar process whereby there isn't an automatic default hierarchy of surrogates. If an agent has not been officially appointed and officially, granted that power of attorney, there is a process by which interested persons are gathered together by the healthcare provider, and they need to come to consensus about who among them will be the decision maker. And then there's also expected to be some discussion and consensus around the decisions that are meant to be made. So you have this very, very extensive default surrogate process that is detailed in the Act. There's obligations and immunities of healthcare professionals. There's a nomination of a guardian, and then there is an optional form, which requires 2 witnesses or a notary for it to be fully executed. The Advanced Mental Health Care Directive Act is very similarly structured with some different emphasis. Obviously, the instructions are limited to focused on mental health conditions, mental health care, and treatments. It also allows for the appointment of a power of attorney for mental health care, an agent, and possible alternates. There's a whole separate section in this statute about the authorities of the agent, which are also discussed in the Uniform Healthcare Decisions Act, just not in the same section. But interestingly, in the Advanced Mental Health Care Directives Act, there is a provision for the withdrawal of the agent. The agent can say, you know what? Cool, you appointed me, but I don't really feel I am able to serve. And there's a whole process there for the agent to withdraw, which is not there isn't a parallel section in the Uniform Healthcare Decisions Act. In terms of obligations and exceptions and immunities, the obligations of healthcare professionals in the Uniform Healthcare Decisions Act are simply that they shall comply. We'd like to think that, but anyway, the statute says shall comply with the instructions, with a few exceptions. They can decline to comply if, for reasons of conscience, or if the instructions are contrary to the healthcare institution's policy, which is based on reasons of conscience, and if that policy has been provided to the patient in a timely fashion. They can decline to comply if the treatment specified in the instruction would be medically ineffective or would be contrary to prevailing healthcare standards. So there are a few exceptions. In the Mental Health Care Directive, it's phrased somewhat differently. Upon being presented with a mental health care directive, healthcare providers shall comply to the fullest extent possible, consistent with reasonable medical practice, the availability of treatments requested, and applicable law. If they are unwilling to comply, they aren't given any automatic outs, but if they are unwilling to comply for whatever reason, they may withdraw from providing care without any requirement that they transfer the individual to another provider who will provide the care. So a little bit differences there. And again, this is existing law. So, this is what you already have in place. There are also in the advanced mental health care directives, there are some exceptions to the obligations and exceptions to the immunities. So it is possible under the advanced mental health care directive statute to subject the individual to treatment that is contrary to the mental health care directive if the providers are under court order to do so, or if it's an emergency in which the individual is at risk of harm to themselves or others. There's no limitation on other authority to take a person into custody. So again, there's a little bit of butting up against law enforcement here on the mental health care side that there isn't on the Uniform Healthcare Decisions Act side. In the Uniform Healthcare Decisions Act, the healthcare providers are immune from various sanctions, civil, criminal prosecution, if they are acting in good faith and believe the Advanced Healthcare Directive to be valid, believe the decision maker has authority, or vice versa. And the agent also is immune in acting in good faith. Same provisions for the Advanced Mental Health Care Directives. Both allow for nomination of a guardian. And interestingly, that I was thrilled to see this. So this is something good in your statutes. Guardians shall comply with the healthcare directive, absent a court order to do otherwise. And this is actually one of the things I would change in the California law if we had it open, because there isn't quite that strong language to say, hey, guardians, follow the healthcare directive. So that's kind of a comparison of what you currently have in place. So you have this Uniform Healthcare Decisions Act that is really focused on physical illness and serious illness, end of life, and the Advanced Mental Health Care Directive, which is really focused on mental health conditions and mental health decision making. Both of them allow for instructions. Both of them allow for the appointment of an agent. So a couple more sort of specific differences here in the Advanced Healthcare Directive. Again, the Advanced Healthcare Directive pertains to healthcare. The instructions focus on end-of-life care. They don't authorize the agent to admit the individual to a psych facility, and they don't affect other mental health care laws. So that's on the Advanced Healthcare Directive side. On the Mental Health Care Directive side, sorry, that should be AMHCD, pertains to mental health care decisions. Now, it's possible for this to either be a standalone document or folded in to the Advanced Healthcare Directive. That's an option in the statute. And the instructions that are sort of laid out in the optional form as well as in the body of the statute are really specific to mental health care and treatment. So there's discussion about particular providers that are preferred, institutions and individuals, particular medications that might be effective or ineffective for this person in particular. Electroconvulsive therapy is discussed, whether I want it or don't want it. Experimental treatment. There's also provisions about notifications. Who should be told that I that I lack capacity or am getting treatment? Who can come visit me and can't? And who should have custody of my children, if I am hospitalized. So a little bit very specific instructions there related to mental health care. In both the Advanced Healthcare Directive and the Mental Health Care Directive, capacity is presumed. That's the starting point. We presume someone has capacity. In the Advanced Healthcare Directive, it takes effect on determination of incapacity in the individual by their primary physician, whether that's primary care or the specialist treating them or the hospitalist, whoever is their primary physician in that moment has the job of determining their incapacity, unless it's otherwise specified. So there is an option for someone to include in the instructions how they want their incapacity to be determined. And the form has a checkbox to allow for the power of attorney to become effective immediately, which doesn't remove the person's ability to make decisions for themselves while they have capacity, but it removes a requirement of that formal determination of incapacity by a physician in order for the agent to act. On the Mental Health Care Directive side, again, capacity is presumed, but the incapacity or recovery of capacity must be determined by either by a supervising healthcare professional who is a physician, plus another physician or licensed psychologist. So the incapacity has a little extra bar there. There have to be two physicians or a physician and a licensed psychologist that are saying this person is incapacitated due to their mental health condition. And the directive itself takes effect when delivered to the healthcare provider, supervising healthcare provider, or healthcare institution, which is a little bit of an odd construction, but there it is. In the Advanced Healthcare Directive, the agent cannot be the owner, operator, or employee of a healthcare institution where the individual is receiving care unless they're related to the individual. And that's the only exclusion. In a lot of other advanced healthcare directive statutes, including California's, the agent also can't be a healthcare professional at all, unless they're related to the individual. So the only exclusion in yours is that the agent can't be the owner, operator, or employee of the institution where the individual is receiving care, which means that they're a primary care physician, potentially, or an outpatient ambulatory, specialist could be the agent. For the mental health care directive, the agent must be a competent adult and cannot be a healthcare provider, supervising healthcare provider, or an employee of the healthcare provider or supervising healthcare provider, owner, operator, employee, blah, 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 unless related to the individual. So again, a little bit nuanced differences between the two statutes as to who can qualify as the agent. In the Advanced Healthcare Directive, there must be two witnesses, and the witnesses can't be healthcare providers, employees of the healthcare provider or healthcare institution, or the agent, and one of the witnesses can't be related to the individual or likely to inherit from them. On the Mental Health Care Directive side, the two witnesses can't be healthcare provider, supervising employee, owner, operator, employee, the agent or alternate agent, and neither of them can be related to the individual or likely to inherit. So you'd need a whole chart to kind of figure all this stuff out. So of note, to summarize, one of the challenges I think that perhaps they were hoping to solve here, there is no effort between these two statutes to clearly delineate physical conditions, healthcare, or treatment from mental, except for a few specified items. So the Advanced Healthcare Directive talks about artificial nutrition, hydration, talks about pain relief, talks about ventilation, very specifically. And in the form, there are sections in the form where those things can be specified. In the Mental Health Care Directive, we're talking about ECT, we're talking about medications, et cetera. But if there should be overlap, there's no effort to clearly delineate which instruction rules, except that the more recent instruction rules in the case where there's conflict. So it's all about recency. It's not about the class of the treatment, the class of the instruction. And there's no mechanism, importantly, none, to reconcile any potential conflicts between the Advanced Healthcare Directive and Mental Healthcare Directive agents or the instructions. So it's like we have these two standalone things, and the assumption, I think, kind of going back to that early philosophical part of the conversation, the assumption is these are two different populations. An Advanced Healthcare Directive really refers to someone perhaps who is older, someone who is very ill, someone who has a physical illness who's approaching the end of life, whereas someone who's got a psychiatric condition, maybe they're 25 and they're having a sudden onset of schizophrenia, or they're middle-aged and they have serious depression, or they're bipolar. There's kind of an assumption that never the twain shall meet, but I think we know that the twain do meet. And that's, I think, one of the challenges of having the two statutes. So that's all what y'all got going on right now as of today. And I think I understand from conversations with Jeanette that the Mental Health Care Directive is perhaps not much in use, perhaps not all that well known in Hawaii, but nevertheless, there it is. It is in statute. So let's look at the proposed legislation, and I've kind of divided up some things into good, bad, and uncertain here, again, in my opinion. So there are some good things and I think those of you who worked on the 1999 Uniform Healthcare Decisions Act will be relieved to know that some of the best things, again, my opinion, some of the best things in your law are preserved. So the goal here is to combine these two separate statutes and two separate processes and potentially, two separate forms, two separate sets of instructions into a single statute, into a single instrument to cover both, physical illnesses and mental conditions. There is virtue in simplicity. There's virtue in bringing them two together, especially because there are these kind of slightly weird misalignments and even contradictions between the two that perhaps can get complicated in the implementation. You will be relieved to know that your default surrogate process is intact. That is the Uniform Healthcare Decisions Act revision sanctioned by the Uniform Law Commission in 2023 put in that, kept in there that default hierarchy of first spouse, then adult child, then sibling, then blah, 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 based on relationship, very rigid, based on kind of my opinion, old ideas of the nuclear family and how families were constructed with no real consideration as to who might know the patient best. So your default surrogate process where interested persons are gathered together and they select a decision maker, that is intact. Furthermore, there are no restrictions on the default surrogate's authority. In your existing statute, the default surrogate, as distinct from the agent, cannot make a decision to withhold or withdraw life-sustaining treatment, specifically artificial nutrition and hydration, without two physicians coming on to say, yeah, if we keep doing that, it will only prolong this person's dying and won't really be medically effective. So there's an extra hoop that a default surrogate has to jump through to withdraw artificial nutrition hydration. That it has been eliminated in the proposed legislation. That particular restriction for the default surrogate does not exist. Interestingly, in the proposed legislation, only one witness will be required for the Advanced Healthcare Directive. And we'll get to a possible downside of that, but only one witness, which lowers a barrier to getting them completed. The proposed legislation allows for the specification of persons to not be consulted about healthcare decisions. Now, anybody could put that in their Advanced Healthcare Directive. They could say, hey, whatever you do, don't talk to Uncle Joe, But this very specifically sort of prompts the person to think about, are there people that I don't want involved in these decisions? And if so, who they might be. And there is language and special provisions to allow for the reality of an electronic record as opposed to a chart or a file. So this Advanced Healthcare Directive might exist in an electronic record as well as a written document. And there is acknowledgement of technology-assisted witnessing. So rather than requiring the witnesses to be physically present with the principal as they're completing the advanced directive, it's possible to do that in real time over Zoom, over an audio-visual medium, or even an audio-only provision. So they're kind of trying to take into account some of the realities of the 21st century, lo and behold. So all of that, I think, is good. Great stuff. However, there's some bad stuff in here that I really would encourage you to think about and perhaps fashion some testimony around. The first is that, and this is true of your existing Advanced Healthcare Directive, but it is still true in the proposed legislation, that a witness may be a healthcare professional who is providing care for the individual, unless the individual resides in or is receiving care from a nursing home and the healthcare provider is an owner, operator, employer, or contractor. So again, what this means is, and again, we're only talking one witness. So the sole witness to my Advanced Healthcare Directive or anybody else's could be primary care physician, nurse, clinic, personnel, someone at the hospital, which makes it convenient, but I worry about some of the conflicts of interest there, and I worry about the relationship that might be established, or the assertions that are needed for a witness to be a healthcare professional. So this isn't the worst thing, but it's just something that caught my eye that since we only have one witness, and that witness can be a healthcare professional, is that really good? Or would we might want to exclude healthcare professionals from being witnesses unless they're related to the patient? This one really kills me. So the proposed legislation allows for co-agents. This is language direct from the legislation. An individual may appoint multiple individuals as co-agents in a power of attorney for healthcare. And quote, unless the power of attorney for healthcare provides otherwise, each co-agent may exercise independent authority. What were they thinking? just,
Oh my God.
it just strikes me as recipe for total disaster.
Yeah.
So, yeah. So that's that red flag. I would try to get that one out. This also is very scary to me. There is, as I mentioned, in your existing statutes, there are immunities given to healthcare providers who, in good faith, follow the instructions of an advanced healthcare directive, with a few limited exceptions. There's a new liability exception here for emergency personnel, people in the ED or first responders in the field. That personnel is not liable for failing to follow an advanced healthcare directive if that violation, meaning they're failing to follow it, occurs in the course of an emergency in which EMS believes the care is necessary to avoid imminent loss of life or serious harm. The failure to comply is consistent with accepted standards of the profession and the professional, and provision of care does not begin in the institution in which the individual is receiving care. So this exception gives gets them off the hook from following any advanced healthcare directive, or for that matter, likely POST, forever and ever, amen. Because when else are they going to be following an advanced healthcare directive, if not in an emergency where the person is likely to lose their life? And in the field, at home, somewhere outside an institution. This is a loophole you could drive an ambulance through. So I would be very, very concerned about that. And by the way, this is straight out of the Uniform Law Commission model language. And I don't like it there, don't like it here. So that's a big concern. A bigger sort of category of concern is just that, again, even though we've now brought these two statutes together, we've brought perhaps the two forms together, the two processes together, we still have not resolved the potential conflicts between an advanced healthcare directive and the advanced mental health care directive, either in the instructions or in the agents. Because again, this combined statute nevertheless still allows for separate sets of instructions and appointments of separate agents for healthcare and for only mental health care. The only conflict resolution that is put up there is that when specific instructions conflict, the more recently executed instruction prevails. So if I have an instruction in there about ventilation or artificial nutrition, hydration, and I happen to have that in both my advanced directives, and one says yes and the other says no, the most recent one will prevail. There is no provision to resolve conflicts between agents. And there's a lot of language in this proposed legislation that the mental health care agent has responsibility only for mental health conditions. Well, there are a lot of conditions where the line between physical and mental is not that clear. Parkinson's, Alzheimer's, you name it. There are a number of situations where it may be an organic disease, but the manifestation is psychiatric or neurological in nature. So who's on first? who has the ball in that case? And if they disagree, how do you resolve that? There is no provision in the statute for how to resolve, Does the healthcare directive agent supersede the mental health care agent? Is it the most recent one appointed? How do we resolve that? There's nothing about that, and there is no clear articulation of the line that the statute might draw between healthcare and only mental health care. So they kind of mashed it into one statute, but they haven't really resolved the underlying conflict between the two. So that's the bad stuff. There are some things that I think are a little uncertain. It kind of depends on where you land on some of these issues. So here's what we've got. The determination of incapacity. As we mentioned, in existing law, in the Advanced Healthcare Directive, the determination is made by the primary physician. And in the Advanced Mental Healthcare Directive, the determination is made by a supervising healthcare provider and an additional physician or licensed psychologist. In the proposed legislation, it allows for a court finding of incapacity and then requires, in order for incapacity to be determined, requires an examination by a physician, psychologist, or advanced practice nurse, and explicitly excludes from the class of people who can determine incapacity family members, cohabitants, surrogates, etc. When I first encountered this, I put this in the bad column because having been an advanced healthcare agent for my mother and several other people, I felt like I probably had the best sense, honestly, of when she was with it and when she wasn't. And I also knew that she was absolutely with it at 8 in the morning and not at all with it by 4 in the afternoon. Requiring an examination to determine incapacity for my authority as an agent to kick in and relying on somebody else to do that was just impracticable, And honestly, I felt somewhat unethical. However, I was schooled by an elder law attorney and reminded that some family members are not to be trusted with the determination of when grandma has capacity and when she doesn't. So depending on where you land on that, the proposed legislation, this is either good or bad, explicitly is excluding family members, cohabitants, surrogates, or family members of cohabitants and surrogates from making that determination of incapacity. It does allow for judicial review. So if someone is declared incapacitated, somebody can complain and take that to court and get it reversed, or vice versa. And the Advanced Healthcare Directive may include a provision to allow the authority of the agent to begin immediately. So that is in the proposed legislation as well as in the existing law. So again, good or bad, depends on where you land on that. There are some differences in the limits and exclusions on the agent's authority. So in existing law, as I mentioned, the default surrogate can't withhold or withdraw artificial nutrition, hydration, unless 2 physicians agree, blah, blah, blah. The default surrogate also in existing law cannot base decisions regarding life-sustaining treatment on the individual's long-standing disability or economic circumstances, which I kind of hope would be true in any case, but it's in the law. And neither the agent nor the surrogate can authorize admission of the individual to a psychiatric facility unless that's specifically allowed in the directive. In the proposed legislation, those couple of limitations on the default surrogate's authority have been removed. There's no limitations. Default surrogate have exactly the same authority as an appointed agent. They cannot authorize the admission of the individual to a psychiatric facility is pretty much the same, but then there is this for not more than maximum number of days or as specified or 30 days, whichever is less. So again, good or bad depends on how you feel about those limitations, whether they were appropriate or not. The allowed reasons for healthcare providers to not comply with the Advanced Healthcare Directive. As I mentioned, in existing law, healthcare providers can say, I'm not following this for reasons of conscience, if the instructions are contrary to a policy based on conscience, if the treatment specified would be medically ineffective, or would be contrary to prevailing healthcare standards. This is very, very typical, of advanced healthcare directive law. The proposed legislation is a little different. Instead of reasons of conscience, we have contrary to the healthcare professional's religious belief or moral conviction, contrary to the healthcare institution's policy, nature of which not specified, but does require timely communication to the patient. If the treatment specified is unavailable to the healthcare professional or at the healthcare institution, they can say, we can't follow this because we don't have that treatment. We can't do that here. If it would be contrary to prevailing healthcare standards or would violate a court order or other law. Because this is a little complicated, here are the differences. In existing law, we have an exception for treatment that would be medically ineffective. That doesn't exist in the proposed legislation. In the proposed legislation, we have the policy has been unhooked from reasons of conscience. We have the treatment, if specified, is unavailable, and the court order or other law. So a few differences there on when healthcare providers are allowed to not comply. There's a whole section on judicial relief, and what this means is if there are objections to all of the above, who can complain and who can petition the court for it to be different. In existing law, that's limited to the patient, patient's agent, guardian, or surrogate, and the healthcare provider or institution involved with the patient's care. In the proposed legislation, we've got individual, which is kind of different language for patient, but individual, the individual surrogate, healthcare professional or healthcare institution, and or person interested in the welfare of the individual. And this is elaborately defined in the definitions and is very extensive and includes the individual surrogate, family member, cohabitant, a public entity providing healthcare case management or protective services to the individual, a financial POA, a person that has an ongoing personal or professional relationship with the individual, including a person that has provided educational or healthcare services or supported decision-making to the individual. So the practical effect of this is that they widened the category of people who can complain. If they think that the agent isn't doing a good job, the agent isn't the right agent, the incapacity or capacity isn't right, et cetera, et cetera. So again, depends on whether you think that's a good thing or a bad thing, but it's definitely widened the group of people who can complain. So this is the really interesting one. I don't know how up on your Greek mythology you all are, but there's this fellow named Ulysses, yeah, and he went to the Trojan War, and he was a famous soldier and yada yada. Once the war was over, he decided to go home, but it took him 10 years. And the reason it took him 10 years is he had all kinds of adventures along the way home. And one of the adventures was that he rode his ship, sailed past the famous island of the Sirens. And the Sirens were these mythological, female, scantily clad individuals who had such a compelling song that anyone hearing their song would feel compelled to row toward their island. But there were horrible, dangerous reefs, on the approach to the island, and invariably the ships were wrecked and the people were killed, So the Sirens were famous for their beautiful song, but also for the deadly consequence of hearing it. So Ulysses, being kind of a macho guy, decided that he wanted to hear the song, but he also wanted to protect himself and his sailors from the possible outcome. So he had all his sailors stuff their ears with cotton so they couldn't hear anything. And then he had them lash him to the mast. So he's lashed to the mast of the ship. He does not put cotton in his ears. He wants to hear the song. And what he tells them is, if you can hear me and you hear me beg you to let me go and to plunge into the sea and go toward the island, don't let me do it. I won't be in my right mind. I just want to hear the song, but don't follow my instructions because I won't be in my right mind. This is called a Ulysses Pact. And there is a Ulysses Pact clause in the Advanced Mental Health Care Directive that is now in this proposed legislation. And what it says is an individual may direct in an advanced mental health care directive that if the individual is experiencing a psychiatric or psychological event specified in the directive, it has to be specified, the individual may not revoke the directive or part of the directive. So what this means is that if someone is experiencing a psychiatric crisis of some kind, and they have an advanced mental health care directive that says, do this, do that, don't do this, don't do that, they cannot revoke that in the midst of that psychiatric event. It has to be followed regardless of what they say. So it's a Ulysses clause. So it binds the healthcare professionals to following the advanced directive, irrespective of what the individual says in the moment. So there's a lot of ethical conflict around this, a lot of ethical angst around it. There are special immunities in the proposed legislation to say, hey, if you follow this Ulysses clause, it's not called that, but if you follow the Ulysses clause, you're off the hook, you're good, you're not liable for any adverse outcomes. And it also requires that if the directive includes this stipulation, it must be signed by two witnesses, not just one, but two who are physically present, can't be remote, and are not the agent, spouse, blah, 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 blah. So there is this Ulysses clause in the proposed legislation. It requires two witnesses, and it's somewhat controversial. I put it in the uncertain category because, again, it depends. How do you feel about that? I will mention that it was this Ulysses clause concept or language was included in the Uniform Law Commission's Uniform Healthcare Decisions Act revision right up to the last revision, and then it was taken out. So it's not actually in the proposed revised Uniform Law Commission model legislation, but it was in earlier versions, so it has been picked up. And some people feel it's really, really important because you want to be sure that the directive is followed, even if the person is not in their right mind. So that's where we are with good, bad, and uncertain. I'll just leave you with because that was a lot, and I'm sure you'll want to go back and review this, but I'll just leave you with what I think are the biggest issues that really should be changed, if possible, through the legislative process. One of them is that EMS loophole. You can't have that because it literally will invalidate all advanced healthcare directives and all uses of POLST in the community if EMS are allowed to just ignore it. Can't be done. There has to be more conflict resolution between the Advanced Healthcare Directive agent and instructions and the Advanced Mental Healthcare Directive agent and instructions. Who is on first? Which one prevails? That has to be better delineated, in the two. And dear sweet Lord above, can we possibly get rid of the co-agents? Agents, alternates, great. But co-agents is a recipe for disaster. Again, my opinion. All right, so I am going to stop talking and listen to your questions if you have them.
No, this is amazing. Thank you so much. Wow. As always, I learned from you, but thank you so much. I think this was what a great, not over an overview, but not only the overview, but some issues really to look at. So thank you. Marilyn actually already has a question, and I was saying to people, so feel free to raise your hand. We can ask questions. Uh-oh. Marilyn, can you mute yourself? Yeah. So Marilyn was wondering, why is there such a haste to pass this nationally without due diligence, which is certainly on us, and how many states have passed this? And I was looking at that chart, Jennifer. I could see that Utah and Delaware passed it. and didn't know if you've heard anything. And then other states were thinking about
Yeah.
it. So do you have any insights as to what's going on nationally?
I
Um,
don't,
have you heard anybody super
I
excited
haven't,
that
and
they
I haven't,
passed it?
and
Okay.
I confess I haven't looked at the Utah and Delaware to see. I mean, I would expect that they would have not passed it just wholesale. They would have done some mashup, with what they currently had, but I haven't looked into it. And CTAC was very keen on this revision of the Uniform Healthcare Decisions Act, and kind of for a brief while there, right after it was approved, were really kind of pushing it and suggesting that the state associations take it up and yay, we got to get this passed. And honestly, I think a lot of people looked at it and said, "Nah, we're good."
Yes, and I think that's I must say from my side, what I hear from our people in the serious illness world is, sure, we could make improvements, but it's not really broken. We
Yeah.
don't, it's working fine. And given all the other priorities and things that are happening right now, no, like we're fine. I will say for mental health colleagues, I don't know if what they think. So, if folks work with mental health, if people work with the mental health departments at their hospitals or their health systems, or they have friends, please reach out so that we, hear from them about this. I think that that for me is a question, but drive inside. Okay. Uh, so I'm wondering if anyone else has questions. Daniel Fishberg said, thank you. You highlighted all the concerns, plus picked up on the loss of medical ineffectiveness language, which is also interesting. So that's good. Um, And again, I haven't understood from anybody on our side in Hawaii why this must happen immediately. That isn't clear to me. We certainly need many, many years to make seemingly simple things happen. So I appreciate that. Any other questions that people have? Okay, Judith, you raised your hand.
Yes,
And
sorry,
can
I
you
come
introduce
from,
yourself,
yes, I'm with the
Judith?
League of Women Voters, and I am a
Great.
legislative advocate.
Super.
And um, my question is, has this bill been introduced in this legislative session? And if so, does anybody know what the number of the bill is so that I can track it?
In fact, yes. And I'm about to put it into the chat. And in the announcement for this meeting, I put a link to that as well.
Oh,
So
thank you.
these were both
Sorry.
introduced yesterday. So if you checked yesterday, it hadn't been introduced yet. So there you go.
Well, and I'll just
Which
say that I looked at HB 2257. I assume the other is identical.
I think so too. Yes.
So you never know, right?
Yeah, exactly. And
Yeah.
again, so as a reminder to folks, we only learned about this last year. We missed it. And we wrote a letter to legislators with some concerns. I think we had 9 points. Um, looking back, there were some questions about capacity and decision making and things like that. But a number of things that Jennifer brought up today are also in there. So again, we hope that if after today you think, oh, I should weigh in on this, those are, Jennifer has really laid out some issues that are definitely of concern.
Well,
And
and
you'll
I'll
see what we
mention,
came up with
Jeanette,
last year.
I used last year's printout of the bill as scratch paper over the last year, so I didn't have to go back and compare to. So, but my sense is that this is the same as was introduced last year. I don't get the sense that anybody took any of those concerns or objections on board before reintroducing it.
Right. Lou, you have your hand up. Lou is with the Disability Rights Center. Fabulous.
Hi, I'm
And I
sure.
will say, full disclosure, Lou testified last year, so he did not miss it. So 100 points to Lou. So
Yeah.
go ahead, Lou.
Well, yeah, and I'm sorry I'm late. I had two other Zoom meetings that I was trying to juggle. So Jennifer, if you've already covered this, then maybe a separate discussion. But and as I had expressed with Jeanette, I mean, what the big issue I had with the bill last year was this thing about the Ulysses clause, and I don't know whether you touched upon that in your
Yes.
discussion.
Yeah, we just talked about that. Yeah, yeah. And I put it, but my sort of analysis was divided into good, bad, and uncertain. And I put the Ulysses clause piece of that in the uncertain category because it all depends on what you think about the validity of a Ulysses clause. Do you like it? Do you not like it? Are you worried about it? It's in there. So it kind of
Right.
depends on how you feel about it.
I mean, I guess the concern that I had last year, I mean, we at the Disability Rights Center, we're concerned about protecting people's legal rights, right?
Right.
And so one of those legal rights would be to not be involuntarily medicated without a court order or some legal proceeding basically being followed. And so, the concern that I had was that you sign this piece of paper that says, hey, if push comes to shove, it's okay. I agree it's okay to go ahead and medicate me. And then when that moment comes, then the person, then instead of going and getting a court order, they're just waiving this document and said, hey, you signed this thing, so off we go. On the other hand, when I speak to like the people at the governor's office who support this, they say, well, it's a matter of choice, and if somebody truly knows themselves, and if they know that if they're having an episode, they may then say they don't want to get medicated, but they know that they really should, and maybe they should have the right. So it's an interesting philosophical question, I guess. But as a legal point, I've always had concerns. So I mean, you have concerns about that as well, or you're that's kind of kind of in the middle.
I think my concerns kind of are not so much on the philosophical rightness or wrongness, but the practical implementation of it. Because as I mentioned early in the presentation, it seems to me that advanced healthcare directives and mental or psychiatric healthcare directives kind of were launched on different tracks, and they're trying to mush them together now. And the assumption about the psychiatric advanced directives is that this is someone who has a serious psychiatric condition that may put them into crisis, may put them into a state of incapacity, but from which they are likely to recover if the right treatment is given in a timely fashion. And that crisis may be sudden, it may be violent, it may be in the community. My concern is, how the heck is anyone going to know that you have a psychiatric advance directive or that a Ulysses clause is included in it? So interestingly, in California, we have a pilot program going on. I think there are as many as 11 counties that are involved in it now that are piloting a psychiatric advance directive. And it lives in an app, and the app is accessible to law enforcement. That's the sort of registry communication route that this pilot is moving toward. Not EMS, not emergency departments, not hospitals, but law enforcement, because they know that law enforcement are the people who are likely to be on the scene of a psychiatric crisis, of the kind for which this directive is, I think, originally and perhaps most appropriately intended. So again, my concerns that by mushing them together, we now have something that lives in a medical health record that is not likely to be accessible in the moment. And forgive me for saying something that might be a little bit offensive, but if I'm naked and running down the street, I'm not going to have my advance directive on me.
Right.
So how would anyone know? So that's my biggest concern. And I also think that law enforcement or first responders, we're putting them in a heck of a bind, putting them in a heck of a place. to have, because they're going to have to be the ones in that moment trying to determine, is this person in their right mind or in their wrong mind? Are they incapacitated in this moment? Do I follow their instructions or do I follow their advance directive? How do I know?
Well, I'm
Yep,
assuming
yep.
that, I mean, it wouldn't necessarily be the cop on the beat that administers the medication in that moment. Wouldn't they take them to Queens or some hospital setting, and
The
then
medication is part of it, but it also has to do with what facility, what provider, what treatment, I mean, there's just a lot, and I think it's asking a lot. Um, I have had the thought, and I haven't spun it all completely out, so there are probably lots of objections to it, but I've had the thought that these psychiatric advance directives really ought to be medical orders. There ought to be a provider involved. Because if I'm specifying medications of a particular kind and a particular dosage, or treatments of a particular intensity, or facilities of a particular type, shouldn't there be a healthcare provider involved in that conversation? And if it were a medical order, kind of more along the model of a POLST and less along the model of a healthcare directive, would that be more effective? I don't know, just a thought.
Well, there's another thought. So good news, Lou, we recorded the whole thing and Jennifer did an amazing job of laying this all out. So I can share once we get it uploaded, I'll share that with you. So,
thank
thanks
you.
for weighing in. And she also talks with with a very nice picture about the Ulysses Clause. So I did want to make sure that we got to Daniel Fishberg's question. He says, I'm not a psychiatrist, but as a medical doctor, I thought the last century of psychiatry was a movement away from a false dichotomy between mind and body. Psychiatric illnesses are a manifestation of brain dysfunction. Having an agent for your mind and one for your brain and body seems antiquated. Why can't folks put their wishes regarding psychiatric treatment into an advanced healthcare directive?
Which they can. It is, you don't have to have these separate. The proposed legislation says all of your mental health, preferences and et cetera can be lumped into your advanced healthcare directive, and you can have a single agent. This would be my preference, single agent, effectuating all of those choices. I don't know why you would ever want to have two separate agents.
Yeah. Does anybody think the co-agent is a good idea? I'm just checking in with team Kokua Mau here. I think I heard Mia gasping. That just seems so counter to what we experience every day. No one is weighing in on what a co-agent equals brain dysfunction. Yeah. That, and I think the EMS, that loophole, that's also really interesting to think about as well. So Jennifer, you've raised a bunch of really interesting questions. And I have to admit that I think for us in Hawaii, our next steps are to be raising our concerns through testimony, because the governor has put this forward as part of his package. The AG has it. So for us, what we really need to do is to speak up and show our concerns about the bill.
Well, and let me also just preface this, that my analysis, was short, and fast, and not and disconnected from the local culture. So I would really strongly recommend that someone on in your group there lay out, existing law, the two statutes, the proposed legislation, and really do a fine-tooth comb between them, because there may be things in there that I missed,
Sure.
or I saw them and I thought, well, that's not important, because it's not important here. So, but then, focus on the hot spots. You can't go in with a whole,
Yep.
line edit, on the whole thing. But so again, from my perspective, it's the EMS loophole, the conflict between the agents, the potential conflict between the agents and the co-agents. Like, oh my God.
But we wanted Marilyn Seeley to talk about the process that happened before to create the 10-page Uniform Healthcare Decisions Act that we currently have, because it was definitely a time where people got to speak up and weigh in. So
Thank you. Yes, those of you that went through that process know that it was a very difficult process. We all had good intentions, for protecting people. We just had a disagreement about the way we do that. And I think the same thing is happening here in many cases. People were very strong in their convictions. But the process to me was extremely important because it doesn't involve just healthcare provisions. It involves the entire culture. It involves our community. It involves families. It involves everybody. And I don't know how we can enact legislation unless all of these stakeholders are allowed to talk about it and to raise the issues, because as many issues as we raised, every time we'd have another hearing, I would be informed, and everybody else, of a new issue that had somebody else's perspective behind it. And I think if we had not gone through that, over and over, and sitting down, and we had the religious community, we had attorneys, we had government, we had everybody involved in that, and it's an arduous process, but I think it's very much needed, particularly for this kind of an issue. I don't think you can push it or rush it or assume that everybody's going to agree with you. And until you get through that process, I think you're sort of out in left field. You're just inviting problems that are going to happen down the road in implementation. And my big concern here was that the entire hospice and palliative care community was excluded. Now, I have the greatest admiration and respect for these people, absolutely. But my goodness, they're on the front lines. They have to go through this every single day, all day long. So why would you leave those folks out? I mean, that makes me very suspicious. Well, I'm so always worried about politics getting into this. And I think that's always, a possibility. And I think we need to keep politics as far out of this as we possibly can. And you just get down to the issues and reach a consensus on these. And we don't need to be in a hurry to do it, because quite frankly, what we're doing now seems to be working. I mean, ask the people that have to do it. And yes, there are some issues, but they seem to be the kinds of issues that lend themselves to having the great discussion over time. Let's not push through a bill. Let's not try to pass the bill and then correct it. Oh, heaven forbid. But let's, do the due diligence and talk and get to some kind of consensus. And people can then, their strong opinions on this, and then we'll work it out. I mean, that's the way we do things in Hawaii. And I think that's the most important concern I have, is that we haven't done that, and we're just going to invite trouble down the road.
thank you, Marilyn. So Jennifer, thank you once again for coming and spending time with us. The amazing Jennifer Moore Ballentine, who is really an expert in a lot of issues in our space. So thank you very much for spending time with us.